It's 8:30 a.m. and this is meeting Senate Natural Resources and Energy. We're resuming our work on H687 and act relating to community resilience and biodiversity protection through land use. Good morning, Mr. Chakowski. Thanks for coming back. Good morning, committee. We are going to keep on doing a close reading, cover to cover, the bill, and continue to flag questions as we go. Goal is to complete a review this week and also start to square up with this bill with 311 so that we can look at a housing bill that's both a housing and Act 250 bill that we can report out to our office with the goal of building out next. So I'll mark my
Age 54.
Yeah, age 54. One, I mark line 20, restart here. All right.
Yes. Ellen Chakowski, Office of Legislative Counsel. So on page 54, this is section 29. It's on the tier 1A area. And so these are the requirements for a town to demonstrate that they've met in order to get the tier 1A area status. And we'll get there in a minute, but it's building towards an exemption from Act 250 in these areas. So on page 54, down line 20. If any party entitled to notice under subdivision C4A, which is coming up on the next page, or any resident of the municipality raises concerns about the municipality's compliance with the requirements, those concerns shall be addressed as part of the municipality's application. On page 55, process for issuing the determination of tier 1A area status. A pre-application meeting shall be held with board staff, municipal staff, and staff of the relevant RPC to review the requirements of subsection B of this section. The meeting shall be held in person or electronically. An application by the municipality shall include the information and analysis required by the board's guidelines on how to meet the requirements of subsection B of the section. After receipt of a complete application, the Environmental Review Board shall convene a public hearing in the municipality to consider whether to issue a determination of tier 1A area status under this section. Notice at least 35 days in advance of the board's meeting, the Regional Planning Commission shall post notice of the meeting on its website. The municipality shall publish notice of the meeting at least 30 days and 15 days in advance of the board's meeting in a newspaper in general circulation in the municipality. Deliver physically or electronically with proof of receipt or by certified mail. Return receipt requested to the Agency of Natural Resources, the Division of Historic Preservation, the Agency of Agriculture, Food and Markets, onto page 56. The Agency of Transportation, the Regional Planning Commission, the Regional Development Corporations, and the entities providing educational, police, and fire services to the municipality. The notice will also be posted by the municipality in or near the municipal clerk's office and in at least 2 other designated public places in the municipality, on the websites of the municipality and the Regional Planning Commission, and on any email lists or social media that the municipality uses. Municipality shall also certify in writing that the notice required by this section has been published, delivered, and posted in the specified time. Notice of an application for tier 1A area status shall be delivered physically or electronically with proof of receipt or sent by certified mail. Return receipt requested to each of the following. The chair of the legislative body of each adjoining municipality, the executive director of each abutting regional planning commission, the Department of Housing and Community Development, and the Community Investment Board for a formal review and comment. Oh, I'll pause there. The Community Investment Board is the new name of the State Downtown Board, which we will get to in another 30 pages.
Thank you, Natalie. I'm not familiar with this word, but
Yes. A lot of new names happening, a lot of rebranding happening. And on to page 57, business conservation, low income advocacy, and other community or interest groups or organizations that have requested notice in writing prior to the date the hearing is warned. No defect in the form or substance of any requirement of this subsection C shall invalidate the action of the board where reasonable efforts have been made to provide adequate posting and notice. However, the action shall be invalid when the defective posting or notice is materially misleading in content. If an action is ruled to be invalid by the Superior Court or by the municipality shall issue new posting and notice, and the board shall hold a new hearing and take a new action. The board may recess the proceedings on any application pending submission of additional information. The board shall close the proceedings promptly after all parties have submitted the requested information. The board shall issue its determination in writing. The determination shall include explicit findings on each of the requirements in subsection B of this section.
Can I ask a quick, sort of term of art, when we're going through proceedings like this, sometimes I'll see that a board can't recess. So does that just mean you're continuing the meetings, you know, you have a meeting, you're not done yet, you recess, you're gonna continue to work? I'm just wondering what recess signifies.
Yes, it is, however, a term you should be familiar with because it's the same one you used here.
Yeah,
It's the same concept. When you adjourn,
Yeah.
it's over.
Right.
Recess is like a break. And so here, this is what happens currently for Act 250 hearings, where if the district commission needs additional information or they want to hold additional hearings, they recess instead of adjourning fully.
thank you.
All right, review of status. Initial determination of status may be made at any time. Thereafter, review of status shall occur every 8 years with a check-in after 4 years. The board on its motion may review compliance with the Tier 1A area requirements at more frequent intervals. On to page 58. In the meantime, the board determines that the Tier 1A area no longer meets the standards for the status. It shall take one of the following actions. Require corrective action within a reasonable timeframe, or terminate the status. Appeal. An interested person may appeal any act or decision of the board under this section to the Supreme Court within 30 days following the act or decision. As used in this section, an interested person means any one of the following. A person owning title to or occupying property within or abutting the Tier 1A area. The municipality making the application or a municipality that adjoins the municipality making the application. The RPC for the region that includes the Tier 1A area. Or an RPC whose region adjoins the municipality which Tier 1A area is located. Any 20 persons who, by signing petition, allege that the decision is not in accord with the requirements of this chapter. And who own or occupy property located within the municipality in which the Tier 1A area is located, or an adjoining municipality. The petition must designate one person to serve as the representative of the petitioners regarding all matters related to the appeal. The designated representative must have participated in the public hearing described in C4. And any person entitled to receive notice under this section have participated in the board's hearing on the application.
So all appeals relate to earning the designation.
Yes.
And okay, and then say there's a 1A. We're referring to the area, a 1A area. And a year into it, someone says, I have some concerns about how it's maybe not following the underlying law. Can they appeal at that point, or
No.
they bring a complaint, or?
So appeal has to be taken within 30 days, like a appeal generally is.
Okay,
So the board has the authority to review status at whenever it wants. So someone, I think, could bring a complaint to the board. There wouldn't be an adversarial process there, I don't think. The board has authority on whether or not to reopen investigation on the status.
and it's often supreme. I'm wondering, I can imagine some people worrying that we won't be able to stand up the 1A area as quickly as people might hope, because it's subject to an appeal. I don't know how you get through designations that people want without also eliminating an important appeal word, to make sure that it really does sort of bona fide. That the designation is both, for good reason. Follow. At least win the status, whatever, earn the status. No thanks.
Thank you, Mr. Chair. That's an interesting conversation about the appeal of the tier. I just have a kind of general question, which is, we've talked about the tiers and their areas as not being like a whole town. And it almost seems like they could be not contiguous with each other. You could have like an area over here and an area over here, and they can all be separate. This process seems to kind of move it all in one thing. Like if you want tier 1A status, it's kind of a process that you would move everything at once. So is that kind of a correct understanding? Like, let's say Hartford applied for tier 1A status, and we designated kind of where our growth center is, and then maybe our village center, whatever we did. Is it all right through that process for it all to go in as one? Or would it be that we would need to do kind of over time, can you have different areas that you add to tier 1A? Because I could see a community saying, we know for sure people are gonna be fine with this being tier 1A, but maybe this is a little bit more risky of a recommendation as an area. Can you move tier 1A statuses later on, or is it once you get your designation to this area, you've got your bite at the apple?
The House did not talk about that in that way at all. I don't think there would be a problem doing multiple applications, but I don't think this language necessarily precludes that.
Okay, but you would do this exact process most likely each time if you wanted to expand or change the tier 1A area.
Yeah. So it lasts for 8 years, so then there's a 4-year check-in and reapplication every 8 years, so you could potentially there would be changes at those intervals. Yeah. I don't think this precludes, so neither tier 1A or tier 1B has a specific size limitation attached to it.
Okay.
Which is something you could consider. But the House did not have any conversations sort of about what you just asked, so you could be more specific about that, like.
Yeah, I guess I don't have like a preference in the language, I just wanna make sure that if a town applies, that they feel like they're moving with their best foot forward and they're not like artificially putting forward a tier 1A or tier 1A proposal based on expectations that politically one or the, I don't know how to put that, like I don't wanna put them in a position where they make decisions that ultimately, because this process is so lengthy, that they would choose a smaller contiguous area, or you know what I'm saying, like to get the benefits, but I don't know how to resolve that, and I don't really have a proposal, it's just a question, so thank you.
Thank you, I guess I would propose that we make it clear that people wanted, if municipality wanted to have multiple areas as part of the same application. Because they may not be contiguous.
Yeah, exactly.
That they could do that in one application. My calculus on this is that they will get appealed and we might as well do all the appeals at once. And just get it all done.
Okay.
Rather than one at a time, and then if there's not also a provision, it could be like how to expand or shrink or change.
Yeah.
That it requires a new application.
Yeah, that's kind of exactly.
That sort of, my sense is from all along when people talk about that, these areas would evolve.
Yes, right, and it sounds like there are regular checks, it's just.
Sir,
I'm wondering if Senator White was thinking about her hometown in this question. But I'm sure there are other towns like this, where you picture a town that has a village in the middle. With a village in this countryside. Hartford has 5 separate villages. And people, White River Junction is not a town, it's a village that's at the Hartford. So. If you just did White River, then what about Wilder? What
Yeah, we should do them all together. It's a complex question, so I just want to thank you for that,
for when? So
Barry.
one application could include multiple 1A zones or whatever they can. And I don't know if we get to language that 2 years in, you might say this project's going really well, we want to bring in another law or
Yeah.
two, something like that. And I'm wondering if you sort of start over or there's an amending
Yeah.
process.
That is not mentioned.
That happens, I think, to think about, thank you. So one application, multiple 1As and amending.
Yeah, non-contiguous areas,
Non-meeting.
you know.
Thank you very much. Anything more before we go on? I think we are. Sorry, I'm getting ahead.
Page 59.
Yeah.
Section 30. Tier 1A area guidelines. On or before January 1, 2026, TRP shall publish guidelines to direct municipality seeking to obtain the tier 1A area status. Section 31 directs the town to update their municipal plans. So down at the bottom of the page, the municipal plan shall identify those areas, if any, proposed for designation. Under chapter 176A/139 and for status under 6033 and 6034, which are tier 1B and tier 1A respectively. On to page 60. These are the exemptions for the tier 1A areas. For notwithstanding any other provisions of this chapter to the contrary, no permit or permit amendment is required for any subdivision development or change to an existing project that is located entirely within a tier 1A area under section 6034. Notwithstanding any other change of this chapter to the provision of this chapter to the contrary, no permit or permit amendment is required within the tier B area approved by the board under section 6033 for 50 units or fewer of housing on a tract or tracts of land involving 10 acres or less. Or,
everyone.
I know, but I want to make sure everyone else was. Or for mixed use development with 50 units or fewer of housing on a tract or tracts of land involving 10 acres or less.
About, so Z1, what on a big picture for properties already under that have an Act 250 permit. What was, and then my understanding is most permits have conditions attached. What happens to those conditions? That area be part of the 1A? Do they?
We'll get to that on the next page.
All right,
We have already talked about this before, but we'll get to it on the next page.
there's something so good you want to talk about them more than once, okay?
Line 18. Upon receiving notice and a copy of the permit issued by an appropriate municipal panel pursuant to 24 VSA 4460F, a previously issued permit for a development or subdivision located in a tier 1A area shall remain attached to the property. However, neither the board nor the agency of natural resources shall enforce the permit or assert amendment jurisdiction on the tract or tract of land unless the designation is revoked, or the municipality has not taken any action to enforce the conditions of the permit. So that partially starts to answer your question, and there's more language in section 33, which is 4460.
Okay.
But so this is part of the transition between going from having Act 250 jurisdiction over these projects to having the municipality be in charge of them. And so the areas are being exempted, and then A&R, the board at A&R lose their enforcement authority over those permits unless the municipality is not doing its job.
I would establish that.
So, there needs to be, probably a complaint. So if the municipality has to take action to enforce the conditions of this permit, and this is talked about more in the next section. And if they don't, those agencies have the ability to start enforcing again. How that would play out practically, I think would probably be, it's not dictated specifically, but I think there would have to be a conversation between the NRB and the municipality. There would probably be some investigation enforcement conversations.
And awesome.
Thank you. I guess I just want to flag on line 3, the word any action. Because like, let's say some action is taken, but maybe it's not all of it. I guess I want to assume that municipalities are going to be good actors and do their job, but like if the phrasing of this, I think would require that the municipality didn't do anything. And that seems like a pretty high bar. So basically, like, I'm wondering about the word "and" there.
So I think this is a policy question that you have to think about, because anytime someone has enforcement authority, they have enforcement discretion. So
Okay.
the House was concerned about towns not doing anything. People who have enforcement authority over permits can evaluate whether or not a violation of those permits rises to the level to necessitate enforcement. And so a town potentially could be being judicious or trying to allocate resources
Right,
frugally.
okay,
So that and then there are maybe someone who doesn't have staff and isn't doing any enforcement. So the House was concerned about no enforcement and just pretending that they're doing something. What?
Is a phone call saying what's going on up there? Is that any enforcement?
I don't know. What is I don't understand. Maybe, I
There's
don't,
something going on within the district and no one in the town knows what it is. They call up and say, what's going on up there? And
who's calling?
the town, manager.
Calls a business or a permit holder?
Property owner.
That's not necessarily enforcement. I think that's like the start of potentially an investigation.
I think someone was asking if any acts an action, but it's not enforcement.
So I need for the flag, right, it could be. This is like the difference between everyone acting in good faith versus someone saying, I made a call, we took action, we're good to go.
I see, well, and like, if somebody's being judicious and they maybe don't do one aspect of it, is
Right.
that grounds for, removal of the whole thing, and that feels like too much.
Yeah, yeah.
So anyway, I just,
Okay, just.
Oh, I'm happy to hear other suggestions on language here. If there's
We're-
more
I
detail.
think we're gonna flag it as of interest and keep hiking.
I think there's a large gray area here. And good minds will differ. on what is and what isn't adequate enforcement.
Well, then,
But so I think that's a discussion that maybe needs to happen.
yeah, the language isn't adequate, it's different.
I'm gonna write on my copy, the word reasonable. Because there's law around reasonable.
Okay.
Made a reasonable effort. To enforce the permit. Something like that. Right, get it out of hot water. And then that opens doors to all the, what's reasonable stuff, but if you're gonna end up in court, I will. Get in the door of house of work, okay?
Yeah, and maybe investigate or enforce is different, Because neighbors calling to complain about neighbors may not require enforcement.
Or it may. And there may be a difference, honest difference in opinion.
There was, one of my favorite clippings on attending was from the police law for Bristol, Vermont, quite a while ago. It said a complaint was filed with the police for noise. And a radio was playing loudly, and they went, and it was a radio playing loudly in the garden to try to keep a woodchuck from returning to their garden. And it said, the woodchuck was observed a short distance from the radio. Alright.
So on page 61. There are 3 additional exemptions added to this section. These are floor amendments.
The AA through.
Yes, so on line 4 on page 61. No permit amendment is required for the construction of improvements for a hotel or motels. Converted to permanently affordable housing developments as defined in 24 VSA 4302. So, I believe, though I'm not 100% sure, that this is the language from 311, these 3 amendments. So I do want to flag that there is a definition of affordable housing in Act 250. So having a cross reference to 4303, you could look at those definitions. Might just be simpler to reference the Act 250 affordable housing definition.
You're right, another, okay.
Yep. Next, no permit or permit amendment is required for the construction of improvements for an accessory dwelling unit as defined in 4303. So this one, I do want to flag some potential issues here. So typically, an accessory dwelling unit does not trigger Act 250 itself. Because these are small dwellings that either within or adjacent to a single family dwelling. They may trigger Act 250 if the property itself already has a permit on it. And so there would need to be a permit amendment. Another sort of question I have is. Well, so another way it could trigger Act 250 is if a developer is developing a series of dwelling units. And is adding accessory dwelling units to them, which would then kick them into from 10 units to 9 units into 11 units or something. So that's another way it could trigger Act 250.
Can I, so on ADUs though, I thought they had to be owner occupied single family homes.
Yes.
Definition by definition, so.
Yes.
But how would a developer do this?
If they constructed them in the initial stage. I guess the only reason I'm concerned about that is because it was mentioned on the floor. As a potential example, so someone is thinking that that is potentially how Act 250 could be avoided that way. So the sponsor of this mentioned that developers who were developing units could use this provision to remain exempt from Act 250. So I think it's an interesting question because who? Yes, typically. Well, it's an interesting question at what point, who is the applicant? Anyways, I have some questions about how this would play out. Also, the definition of in 4303 doesn't have the limit of one per. One per parcel, that's actually in another section, so that's why I'm concerned, so. I think it's a little odd, but
Is there a different cross-reference that seems more appropriate than 43?
well, it would probably. Have to, well, so it's also in 43. Or 44, it's in 4412 also. So, anyways, this probably could use some additional
Scrutiny,
work.
okay. Alright, we're into it, wow.
And because the house had not considered this language. Before it was added as a floor amendment.
The amendment was not brought to the committee.
It was brought to the committee, but it wasn't. It wasn't part of their bill work.
You happen to know if they took a committee position on
Yeah, they voted against
The ADUs.
for this whole section.
it? A, B, B, C, C.
Yeah,
This was one, the whole thing was one.
yeah.
Okay, thank you.
And then no permit amendment is required for the construction of improvement for converting a structure used for a commercial purpose. To 29 or fewer housing units. This has been discussed in prior sections. But it hasn't ever passed before, so. This would be if a commercial structure has an Act 350 permit, they wouldn't need an amendment to convert it to housing units. I think there are pros and cons to this, going from an industrial park to housing would have different permit conditions. It also doesn't necessarily say that the housing units have to take up the entire commercial structure, so there could still be some kind of commercial purpose happening and with housing added to it. So,
Mixed use.
mixed use, yeah, so,
In 311, there was a provision like this.
yes.
Is it also 29?
Yes.
And this would take place in tier one places or any place in the state.
Any place, well, it wouldn't be tier, one, because tier one's already exempt.
Sorry.
Mr. Chair,
Just yes.
before the meeting started, there was an informal discussion about a dairy barn somewhere that suddenly turns into a restaurant that's
Yeah.
serving meals. Could that be a commercial establishment that could then be converted?
I don't know the specifics, but yes, maybe. A commercial structure being converted to housing,
Do we consider a commercial structure?
is it being used for a commercial purpose? I.e. a restaurant?
Storage, or for storage where you charge people to store whatever meals in the winter time, and things like that, so commercial purpose.
Yeah, so almost everything under Act 250, if it isn't a farming purpose, is a commercial purpose, almost anything.
So it's a pretty big door.
Yeah,
It's like a chain of exemptions. Accessory on farm, on farm business. But isolate.
Anyway, so we came into this thing, I just want to double check, I think what I'm saying, so we entered in this section 32, talking about. Dealing with Act 250 permits and stuff in tier 1A, then we get to tier 1B. And now this section here that we're going through, AA, BBCC. This is anyone.
yeah,
This is not a permit exemption related one A and one B.
Yeah.
Okay, thank you for saying that. I have appreciated how both the scope.
So we have a little red flag next to that.
Or purple or pink.
Okay, so any other questions on 32 pro con? Thank you.
On page 61, section 33, so this is going back to tier 1A, and this is about the municipality's responsibility. Now that they have this tier 1A status. So this subsection shall apply to a subdivision or development that was previously permitted pursuant to Act 250, is located in a tier 1A area under 6034, and has applied for a permit or permit amendment required by zoning regulations or bylaws adopted pursuant to this subchapter. So this is for a project that has an Act 250 permit, but now they're seeking to make changes to their municipal permit. So they are gonna make changes. And they're exempt from Act 250, so they will not be going through that process, but they will probably have to go through the municipal permit process. So the appropriate municipal panel, which is the statutory term for whoever the reviewing body is, it's usually a DRB. In a town zoning panel. So the appropriate municipal panel reviewing a municipal permit or permit amendment pursuant to this subsection shall include conditions on page 62. Conditions contained within a permit previously issued pursuant to Act 250, unless the panel determines that the permit conditions pertain to any of the following. So the panel is supposed to look at the Act 250 permit and transfer over the Act 250 permit conditions into the municipal permit, unless it's one of these, and then they don't have to carry it over. So unless it's from the construction phase of the project that has already been constructed, so no longer necessary. Compliance with another state permit that has independent jurisdiction. Federal or state law that is no longer in effect or applicable. An issue that is addressed by municipal regulation and the project will meet the municipal standards. Or a physical or use condition that is no longer in effect or applicable, and that will no longer be effect or applicable once the new project is approved. So no longer relevant to what the project is going to be.
Can you give us an example of E, what's that mean?
Sure, they totally change what the project is. So if they fully change to something entirely different. And the conditions in the Act 250 permit no longer reflect what's going to be happening at the site. A business that was loud and is being converted to a shop, I don't know.
Yeah, so. For the. Business already has an Act 250 permit. The exemption is not retroactive. Or it is. Do we say, okay, well, now you're not subject to that permit and.
So- The way that this is structured is, Act 250 jurisdiction is perpetual, it still is. This is saying they are exempt. If they're in tier 1A area, they are exempt from needing a permit or a permit amendment. So the permit
New
amendment,
things.
what?
For new things.
Yes, the permit is not being extinguished. It will still exist sort of floating in space. But the town is directed to take the conditions out of it and put it in their permit. So that the town will then hopefully enforce those conditions. As part of their permit review and enforcement process.
But if they don't, sounds like they have some flexibility.
Well, they have the ability to not transfer over things that are no longer totally relevant to the project.
Okay, I'll sleep on it.
Is the idea here that the NRV would no longer need to enforce, or that the municipality closer in would enforce almost on behalf of those original conditions that are still relevant?
Yeah.
Taking out APP.
Yes. So this is a big question of what happens when you exempt large portions of the state from Act 250. What happens to those permits? And so this is one way to address that, is that municipality is to take over. In the last section, you heard that the board and the agency don't have the authority to enforce that unless the municipality isn't doing anything about those permit conditions.
It seems to me if the concern is that Act 250 involves too much citizen activity, too many citizens raising objections, too many appeals, too many hours in court. We're gonna do Act 250 exemptions, speed along to open the path to housing development. Boy, this would be, I jump out of the front end, fire. If I were someone who wanted to stop development, this is a cornucopia of opportunities. Just saying.
Because it's easier to get in to initiate a municipal level appeal than to go to the MV.
No, just you got something else to object to.
So municipal permits and the permitting process of the municipality already exist. And it is not, that process is not changing much except for this.
Well, if the municipality, if you have the exemption. And the municipality decides to enforce as a municipal. Using their municipal authority to enforce. 8 out of 10 conditions on the existing Act 250 permit. You still got 2 that they're not enforcing. And Act 250 is no longer enforced. So it obliterates those 2 requirements. And there are very likely gonna be people who object to that. Say, no, we want those just reading this course.
Okay.
Can I ask Mr. Young was asked a question, is the NRB supportive of the notion of sort of baton pass to municipalities? That the board becomes just sort of a backstop in case someone, thank you. Believes that the municipality is adequately enforcing the condition of the originally attached to the board in the position of the way this is set up, and unless that's, I've inaccurately characterized something that could happen.
I didn't understand what you just said, but I partially didn't hear the first part.
Okay, so I think if there's this sort of passing of the baton to a municipality, now they laid on those conditions to a municipal permit. And then someone said, well, they're not adequately enforced, they say something. Locally, nothing happens, then now there's a process to go back and appeal to the board to say, they're not enforcing conditions, so. I'm just wondering if that construct is something that NRB itself is supporting, like. The pass of conditions to the municipality with the possibility of it getting appealed back to you all. For lack of enforcement.
I'm just gonna flag before they answer, it's not an appeal, it
Okay,
would be a regular complaint,
complaint.
which would happen and which sort of trigger the need for enforcement investigation.
Okay.
What she said.
Yeah, I think
You gotta be careful with the word appeal, people get nervous.
the overall concept seems to be a reasonable approach for what is a tricky situation.
Right, thank you.
Alright, so on page 62,
Senator McDonald.
So if something has been built and passed according to Act 250 permit. And this bill becomes law. Have the requirements of that pre-existing Act 250 permit suddenly subject to being undone, unenforced, or what? what has changed for something there following Act 250? If this bill passes,
So. Not much for a while. So they can continue to operate. If in the future they seek to change what they are doing and they are exempt from Act 250. They would go through the normal process they were already required to go through at the municipality and get a municipal permit update amendment. And at that point, there wouldn't be any potential enforcement from the NRB or the Agency of Natural Resources. If they were out of compliance in some way.
was the one permit they have, it's what this
Yeah.
bill passes.
Yeah. So the area has to be designated, a series of things will have to happen before that takes place, like there has to be the municipality getting the designation. If the operation doesn't change what it's doing and is in compliance with what it's doing, they won't necessarily experience any changes.
Chair Councilman.
Thank you, Sabine Haskell with the NRB. I think what you're asking is, do the conditions from the permit go away, and they don't? It's the intent that they get transferred and they need to continue to comply with those conditions on their Act 250 permit, but it becomes the responsibility of the municipality, so to speak. It's not like we're undoing 1A, 1B kind of thing.
And it's just, it's the municipality, is eager to step in.
Then they're going to be having, then this is the conversation we very vaguely referred to. In that there's going to have to be some role for the board to ensure that the municipality there are. Making sure that the conditions of permits are being followed. And when we get asked about what will staff be doing if there's all these exemptions, that may be a role that gets beefed up a little. I don't, it's hard to say at the moment.
The argument is made from time to time. When an applicant is applying for an Act 250 permit. They will make the argument that they already have their town permits. So Act 250 is redundant. Unnecessarily expensive and time consuming, and you shouldn't do it. Because I have my town permits, I should not have to go through this. That is not the law at present. At present, you are subject to Act 250 and you can go through it. And from time to time, the Act 250 commission, the district commission, will decide that they're more concerned about something than the town fathers were. And there will be conditions on an Act 250 permit to rein in a problem that the town is already on record as saying is not a problem. So in essence, what we are doing, if enforcement of the Act 250 permit becomes the duty and the power of the town and not of the board, then we are affected, and they choose not to enforce certain parts of the permit. Then it seems to me what we are doing is repealing permit, or at least in part, we're amending the permit. And doing away with different parts, or amending. Well, no, the state doesn't do that, the board doesn't do that, the town does. Under the legislation, the town does, and what we're saying is that they can enforce those portions of the Act 250 permit that they see fit to enforce. And on their judgment, at their discretion, not enforce other parts of it. So it's not completely repealing the permit, but it's sending it, it's changing it.
It's rendering it something that wasn't permissible
Yes,
to be permitted
that's right.
by virtue of the law here, or.
That's how I read this, and maybe I'm wrong.
So if we go back to the prior page 61, we had a conversation at the top, first 3 lines. Including the board and shall enforce or assert amendment jurisdiction on the tract or tracts of land unless the designation is revoked. Municipality is not taking, and then we're talking about something like reasonable efforts to enforce the conditions of a permit. Permit in that case, is it referring to the Act 250 permit or? Okay,
Yes,
so there is recourse.
Want to go over that?
My lawyer should probably do this properly, but top of page 61, we have did some rewriting here, but it was, that there is recourse back to the board according to CAR to enforce a permit condition. So in the case of a town deciding it didn't like the condition, someone could bring a complaint back up to the board, say they passed all the conditions over, but they're not following, they choose not to enforce.
That would relieve my anxiety about non-enforcement of Act 250. However, then I would restate that if I were one of the anti-Act 250 folks, think that if you want to get something done, get Act 250 out of the way, is you have just opened your Pandora's box.
Okay, well, so
let's the difference between getting it out of the way tomorrow and getting it out of the way from yesterday.
Yeah.
But getting it out of the way from yesterday is that what we intended to do?
That's a rhetorical question. Yes. So you're looking at me like you're waiting for my answer.
Well, we handed it.
That's first.
That's that happens.
How I feel all the time.
all right, on page 62.
So everyone, we flagged that earlier language. Part of that can be continuing this discussion.
This is a tricky issue. It is something that the committee, the legislature has struggled with since I started, because every year there is a proposal to exempt areas from Act 250, and the question is what happens to those permits? This is one way, and I think you could, add some initial clarifying language if you have some in mind. But on page 62, line 14. After issuing or amending a permit containing conditions pursuant to this subsection, the appropriate municipal panel shall provide notice and a copy of the permit to the ERB. The appropriate municipal panel shall comply with the notice and hearing requirements provided in subdivision 4464. In addition, notice shall be provided to those persons requiring notice under Act 250 and shall explicitly reference the existing Act 250 permit. The appropriate municipal panel's decision shall be issued in accordance with 4464 and shall include specific findings with respect to its determinations pursuant to the list on the prior page about the permit, which permit conditions should be kept or dropped. Any final action by the appropriate municipal panel affecting a condition of a permit previously issued pursuant to Act 250 shall be recorded in the municipal land records. Within a designated Tier 1A area, the appropriate municipal panel shall enforce any existing permits issued under Act 250 that has not had its permit conditions transferred to a municipal permit pursuant to subsection G. So in either case, the town has enforcement authority.
Is H just dealing with that there's some time required to do all this transfer of things?
No. This is about G, the first part that we just read through is premised on the municipality reopening its permit and making a permit amendment, at which point it transfers the condition.
I see.
And so if a business is operating and never makes any changes and just continues to operate, its Act 250 permit still exists and the town has to enforce the permit condition. It's not until there's a change, because otherwise it would force the town to reopen every single permit in town. And that's not what this is saying. It's status quo until there's a change, at which point the permit conditions from Act 250 will be formally pulled into the municipal permit.
with, is there any kind of opening for? I guess I'm just, if I was a municipality and I was going through this process, this may align with an attempt to change designations, like prior to going into this process, like, is there any advantage in this process to redesignating an area before you enter into this? Do you, I guess,
Redesignate, I don't know what the redesignated.
so I'm
You're talking
thinking,
about zoning?
yes.
Talking about zoning.
So like a commercial, so if I'm understanding correctly, if I have a commercial use zoned area in my town, it just continues, if it's in tier 1A, it continues on that. Would it be advantageous for a municipality to change their zoning and then go through this process? In some way, because, or I guess I don't understand how all the permits align up. Like if you're commercially zoned, you stay commercially zoned, there's no change. You go, now you're not under Act 250, you're under your municipal zoning and you're under their bylaws or however it works now, they're your authority. But if you, let's say, wanted to change something as a municipality and you were like, do I do it before we go through this process or do we do it after? Is one or the other easier or simpler?
I think, it may strategically, it might be better to do zoning changes before, because the board will be reviewing the zoning applicable to these areas to make sure they get the criteria.
Yeah.
If there's a zoning change after the status has been changed, the board may seek to ask questions and be like, hey, is this still complying? So they may choose to reopen the status to see if they're still complying. But I don't know beyond that.
Well, it reminds me of our earlier inconclusive.
I know, I'm asking,
And-
I'm just thinking through, like, if I was a municipality going through this process, what would the calculations be that I would be making? And I know we have some exemptions in here, we just went over about if you're commercial space and you convert to housing, then you are exempt. So in a way, I could see certain locations in towns that are commercially zoned choosing not to make any changes because, hey, they're exempt anyway if they want to become housing. But wouldn't you wanna rezone, maybe I'm getting too weeds on this, because you would normally just rezone that residentially. Right, like, so you're kind of gonna, you wouldn't make that decision necessarily because you're exempting those locations in the bill, but you may have, well, I don't know, I guess I'm just kind of, I don't fully understand the decision tree that a municipality would need to make through this process, but I guess that's not really. That's just kind of, it's a decision, not a policy choice we would necessarily outline.
Sure, I mean, I think big picture on this bill is to encourage good planning as soon as possible. So that a town has resources and the ability to respond to this bill and perhaps decide where they want to fall within the new tiers of this bill.
So I think I understand, and I just hope as we go through, if we heard from municipalities that said they didn't follow what was about to happen, that we would make provisions of that clarity, but I don't know what this would be at this point, so, thank you.
Well, and we have, for instance, Mr. Baker, who's been finding on our schedule for
Great.
Thursday.
Hey.
Today.
Oh,
I'm quiet.
okay.
I'm gonna just say, blame it on me, but we have Mr. Baker on the agenda really soon.
Real soon.
Alright, so page 63, section 34. Alright, so we've talked about tier 3, we've talked about tier 1. Now we're gonna talk about tier two. So tier two is defined currently as anywhere that isn't tier one or tier three. And so. Largely, I mean, I think that would be most of the states. Because we are talking in tier one, we are talking about towns with. Relatively robust zoning programs, so how many towns, and those are gonna be areas of town, so they probably will not be whole towns, as we've been discussing. And then the critical resource areas are yet to be defined, but. I do not think it's going to cover that much land area. So tier two is the rest of the state. And largely so far, not much is changing in tier two. In that the existing Act 250 jurisdictional triggers will apply. Plus the road rule. So next is this report.
So in tier two, that, but for instance, in 311, there are exemptions for different levels of housing, whatever it is, 30, 50, 75 or something like that.
Yes.
They were, that's regardless of whether or not you're in tier one or two zone. I mean, they're,
S311, that apply, so tier one is exempt. So it wouldn't apply in tier one. But. So it would apply in tier two and or tier three. But. Tier three has, has any construction of residential triggered Act 50, so that would be primarily tier two then.
I'm just trying to make sure that at scope of the exemption. A lot of territory that's. There's one way to think about tier two or the map of Vermont, color the whole thing tier two. Then go with your highlighter, pick out tier one, A and B, pick out three, and. So in the end, everything's colored in one color or another.
Yes.
So then those exemptions for dual and housing. Outside of, well, they're already, you're saying, they're already exempted in one or tier one. That they would apply very broadly across the state. I think it's the scope of those exemptions, where things will happen. It's of some concern to me personally, counting.
That was the original plan on Act 250. Listen, the whole state would be one color or another. And
I'm just trying to envision what the consequences are, and I'm just wondering, checking on 311. Sarah wants to go.
I have thought that I am. Not sure that I'm ready to share yet. Well, I'm gonna put this idea out there. And. I'm opining. For a second, so I
Right.
apologize for the.
We're almost halfway.
Maybe I'm gonna, yeah, I can't, I have to say it. Okay, so I'm thinking about this broadly, right, like the plan generally, right, like. We are trying to preserve the places that need preserving, and we're trying to encourage development in places where we're trying to encourage development, and. You know, I feel like there's balance between what we're doing with tier 3 and tier 1. And then with the tier 2, that's the middle. And so I am thinking about this in terms of like, I want there to be balance also with tier 2. And what I mean by that is the road rule is like, here's a stick to make it harder to develop places where we don't want you to develop. And I'm not seeing the balance of how do we encourage density in tier 2? Like the carrot rather than the stick. And I maybe that's okay. I know this is what everybody agreed to, so what I am positing is outside of that scope, and I don't know what it would be, but I'm just putting it out there, it's, wanting there to be balance between carrots and sticks in terms of encouraging dense development.
And one possibility is in tier two, even if you're buying at 50 exemptions by apply, if you limited the amount of space that's had. So the exemptions were for dense development, not just
Right.
35 units across 380.
Right, you know, it reminds me of the proposal about like, you know, however many units can be exempt on 10 acres.
Mm.
Right. Anyway, but I realize there's danger in saying this out loud, and so I just want to put out that I'm chewing on that idea. I'm willing to be wrong.
So she puts higher income.
Yes, thank you. If it's okay if I could weigh in, Brian Shu, Natural Resources Council. Two things. I think one of the reasons that we've strongly supported this version of the road rule is we think that it will likely encourage developers to avoid Act 250 by clustering, by developing a more dense pattern of development rather than extending driveways and roads throughout the tier two. The second thing I'd say is that we have been talking with the RPCs and would be prepared at some point this week to give some suggestions for other temporary exemption type of an alternative to the 311 exemptions that might be doable as tier 1A and tier 1B get rolled out by the RPCs over the next couple of years. So we'd be glad to weigh in at something like that if Charlie Baker doesn't today.
Thank you.
I do just want to say, the RPCs are listening, and they, my local RPC informed me that they would definitely be there to help and support with local zoning changes in the interim with tips, so it's go RPC.
Your local RPC is actually watching.
Exactly.
The only thing,
Devices, right? Can't live with them, can't live without. It's like, here we go.
the only thing I would say is a general comment in response to multiple things that have been said in the last hour, which is. I think I think different people have different intent of what this bill is trying to accomplish. So ascribing, so just perhaps you have intent that the House did not have. Perhaps they had intent that you do not fully see. So I'll just say that, and that perhaps not every single thing can be accomplished through changes to Act 250.
Oh, we've heard this before.
So,
Well,
I'll just say that.
the title of 311 versus 687 says it all. I mean, one talks about community resilience and biodiversity protection, land use, the other is put everyone in a house. They're very different sort of energies that come to the table with. And we'll end up with something interesting that is involved.
So, the tier 2 report is in section 34. So it's responding to the fact that there aren't too many changes being made to what will be the tier 2 areas. So on or before February 15th, 2026. The ERB shall report recommendations to address Act 250 jurisdiction in tier 2 areas. The recommendations shall recommend statutory changes to address fragmentation of rural and working lands while allowing for development review. Address how to apply location-based jurisdiction in tier 2 areas while meeting the statewide planning goals, including how to address commercial development, and which shall also include. And so I'll stop there quickly. It's how to address commercial development is vague. But currently, the triggers are, for commercial development, it's 10 acres in a town zoning, 1 acre in a town without zoning. Is because this bill is moving toward location-based jurisdiction rather than use-based jurisdiction, should that change? And there are some additional details on page 64. So it shall include a review of the effectiveness of mitigation of impacts on primary agricultural soils and make recommendations for how to improve protections for this natural resource. Review the effectiveness of jurisdictional triggers for the development of retail and service businesses outside of village centers. And criteria 9L to address sprawl and strip development and how to improve the effectiveness of criteria 9L. And review whether and how Act 250 jurisdiction over commercial activities on farms should be revised, including accessory on farm businesses. So I'll stop there quickly. You will recall that section is at 28B.
Yeah.
Added accessory on farm businesses, that was a floor amendment. The House had been considering just having that be addressed in this report as part of the review of what should happen in tier 2 and if there should be a change. Broadly. And the report shall go to the House Committee on Ag, Environment and Energy, and the Senate Committees on Ag and this committee.
The page 63 on 17. Breaking a statutory change, best fragmentation rural workmen while allowing for development review. So I'm just not quite getting what while allowing for development review. Like, what's that saying?
I mean, that's I think the entire tension of this bill. Is balancing how to prevent fragmentation of certain areas while still allowing for development review. So that's one of the House's big picture concerns.
As opposed to like no review?
Yeah.
They're concerned about like anything goes, opposed to having somebody, okay. So your thoughts?
I think it would make more sense to me if we just took out the word review,
Okay.
allowing
Yeah,
for development.
the review part that makes.
Yeah.
Curious, thank you.
Thanks. How does section 34 differ from? Well, then what's a report? What the report is about, how does it differ from the existing law? Or does it not? Is it just saying you want to report on what the law is now?
No, it's about making recommendations
You know,
regarding if changes should be made to tier 2. Because this bill isn't making many changes to tier 2.
it looks like what's being articulated here. Sounds like a description of the world today. Under Act 250. Allowing for development, preserving the
Sure, but this is 130 pages of changing how Act 250 is going to function.
yeah.
And so moving forward, this is an area that isn't receiving many changes. As they adopt this proposal and move into this new space of all these changes, should other changes in this specific area be made?
Right now, the bill is not calling for a lot of changes in tier 2.
Yeah.
So we want to report making recommendations
Yes,
as to how not changing anything, will not change it.
no, if changes should be made,
Okay, changes that are not in the bill,
yes.
okay. All right,
Thank you, Mr. Chair. Would it be a fair characterization, council, to say that this perhaps is a section to help? I don't actually know if you could respond to this. I'll just make a statement. I think this is in part to alleviate some of the concerns around tier 2 not having made enough changes. So I think it is kind of but maybe I'm incorrect on that. I see there's a hand up that maybe has more. It's a little bit more understanding.
Please.
Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. I think some of the conversations that happened in the House. When 687 was first introduced, tier 2 didn't have the road roll, it had a 500-foot. From any road, and I think there's some community members who don't love the road roll. And so we're looking at the road roll as this is something that was agreed upon in the stakeholder process, this report may give the opportunity for folks to dig more deeply into knowing what the intent is in tier two of how do we encourage density and make sure there's review when density isn't happening of what the impacts could be. Is the road rule the best way to get at it? Is there other options? I think. I don't want to speak for the committee, but that's my understanding of how that process sort of played out, was this would give more time to look into, is this the best path forward? And if it is, then great, if not, then those, something else may come out of that. You know, I think the other piece that we certainly are interested in is if something, the development is triggered by the road roll, so we're talking about one house up a long driveway, to all the pieces of Act 250 need to be, all the criteria need to be reviewed. Because you're not necessarily be impacting traffic or the education system, so those would be pieces we would love to see as part of that, but I think how this came about was just saying, let's move forward with this, because that was agreed on, but there may be further study that could be done.
Yeah, so the question in the room then is in B, the cross reference to 9L addressing sprawl, street development. Is that a way, sort of a backhand way of referring to, we're looking for a more thoughtful, denser, more dense development and tier two, rather than and hoping to avoid sort of sprawling development? Anyone? It's like we actually need someone from that committee, speak for the committee. Right, so. Anything else? It does seem like a relatively light. It's most of the space and. I mean, leave it alone and keep it, help us keep going. 34A.
34A was another floor amendment. The wood products manufacturing report. So the Natural Resources Board, in consultation with the Department of Forest, Parks and Recreation, shall convene a stakeholder group to report on how to address the Act 250 permitting process to better support wood products manufacturers and their vital role in the forest economy. Specifically. Yeah. The group shall examine the Act 250 permitting process and identify how the minor permit process provided for in 6084G has been working and whether there are shortcomings or challenges. So currently 684G a few years ago established that certain wood products businesses automatically go as minor permits as opposed to major permits. So that's one benefit that has already been given to them. And last year, you also gave them the ability to amend their permit changes or their permit conditions. Specifically with regards to hours of operations.
Flexibility for hours of operation. Yeah.
So there's the reference there, and then on page 65. The group may look at permitting holistically to understand the role of permits from A&R, municipal permits where they apply, and Act 250 permits, and develop recommendations to find efficiencies in the entire process, or recommend an alternative permitting process for wood products manufacturers. On or before December 15, 2024, the NRB shall submit the report to the House Committees on Ag and Environment and Energy and Senate Committees on Ag and Natural Resources.
Yeah, I'm not sure why. We, without jurisdictions, doing a force group. It's a little confusing.
They're receiving the report.
Yeah.
Well, sorry, the name of that committee is the Agriculture, Food Resiliency, and Forestry.
Trying to the Senate Committee on Agriculture.
Oh, happy to strike that.
Yes, no jurisdiction in the world of forestry, it's
Well, this was a floor amendment, so.
people maybe in the house don't know that we're organized differently. But
Yeah, perhaps.
Could be.
And I would just also add another flag that this floor amendment. Added this section and also struck reference to wood products manufacturers that were actually included in the tier 2 report. So the tier 2 report, as passed out of committee, referenced that they should also look at specifically permitting for wood products manufacturers and forestry related businesses. And gave them their own report that's due later this year. Yes.
And,
To me, that's this holistic, legal term. I may be showing I think of holistic as a kind of agriculture jargon. It's become a real word. It's used all the time, but is it actually a word?
Yes.
It is not, okay, it really wasn't once, it has in our time become a word.
Okay, I'll just say that generally, I don't love adverbs generally, so. You could, straighten out.
Yeah, this is-
adjectives also, but vital.
Yes, yes, vital.
Everything you do in business with all there is vital.
Mr. Chair, I'm just looking up doors with plastic lumber. Costco in their this month's sales are chairs made with plastic lumber. And we're talking about the vital forest industry, which is also vital for carbon sequestration and flood resilience. And we're looking at competing now with plastic lumber.
Well, years ago, when the Diamond Run was selling apartment down in Rutland, it was sold as a holistically designed shopping center. So much for the hippies.
There is one business that's on the sign there now. It's a big, huge roadside sign that has one business that I've been running.
Before we leave this section, I'm just gonna, because I said something, the word vital. Having logged for a year, my 20s, I have great sympathy and interest in the industry, live in a place that's very full of it. I have a general predisposition to not having adverbs and adjectives in things, because they're a little troubling when they crop up. But we go into it if we start writing that way. Okay, so 34B, please.
34B was also a floor amendment, and it is another report. On. Section 34A was Sims and. Maybe more.
What, Supernut. Oh, okay.
And 34B was bus.
Maybe they want to. When they get the table. All right, so let's go.
On report February 1, 2029, the ERB shall review and report on the new tier jurisdiction framework used to establish location-based jurisdiction for Act 250. The board shall report on the outcomes and outline successes and any changes that are needed. The board shall undertake an in-depth review of the Act 250 updates, including the duties and responsibilities of all the staff and the board itself. Specifically, whether the updates have reduced appeals and whether the updates have created more equity and cohesion among the district commissions and district coordinators. So I will flag that the NRB does submit an annual report every February anyway. And this is about 2 years after the tiers will have taken effect. Past this.
What's the argument for doing?
How is it going?
Well, we generally do that.
Yes.
Let's see if we have one more second done before taking a break.
All right, so section 35 is another report. This is a report primarily about affordable housing. So the Department of Housing and Community Development, BHCB, the Land Access and Opportunity Board, and VHFA shall engage with diverse stakeholders, including housing developers, local government officials, housing advocacy organizations, financial institutions, and community members to identify regulatory policies that incentivize mixed income, mixed use development, and support affordable housing production as a percentage of new housing units in communities throughout the state, including examining the impact of inclusionary zoning. And develop recommendations for legislative, regulatory, and administrative actions to improve and expand affordable housing development incentives within state designated areas. And then they shall submit the report by December 15th of this year. To Senate Committee on Economic Development, Housing, and General Affairs, and Natural Resources and Energy, and House Committees on General and Housing and Environment and Energy with its findings and recommendations. So what's happening here is, so you saw in 311 that the concept of priority housing project was being repealed. Because if there's full exemptions in the designated areas, or what would have been, or what have been currently our designated areas, priority housing projects may not exist. I think it potentially remains to be seen, but in theory, the areas that are currently designated areas where priority housing projects currently exist would already be covered by a larger exception. Yes. So priority housing projects, to remind you, is an exemption for mixed income, mixed use housing that requires a percentage of the housing to be affordable. And so it is an incentive to build a percentage of your housing as affordable so that you can be exempt from Act 250. If there's a full Act 250 exemption for a Tier 1A area or a full exemption for any kind of housing in Tier 1B, will there even be places where priority housing projects are developed? So this is asking some housing experts to come back with suggestions about how to address this incentive that's being lost potentially.
I would love to know the answers to that question too.
Okay, so sort of all. Marking my probably think about and wonder about priority housing ones. Which 311. With that, thanks for everyone. Let's take a break till 1/4 after. And crash out.
Yay.